Every agency relationship in real estate, whether between a broker and client or a salesperson and employing broker, has a natural lifespan. It begins with mutual consent and authority and ends when the purpose of the relationship is fulfilled, revoked, or made impossible by law. Understanding how and when an agency relationship terminates is critical because the duties and liabilities of a licensee are closely tied to the duration of that agency. When agency ends, so does the fiduciary authority to act on the client's behalf. However, some duties, such as confidentiality and accounting, may extend beyond termination. Under Arizona Revised Statutes, ARS, Section 32-2153, A3, and Commissioner's Rule R4-2, 8-1101, an agency relationship may be terminated either voluntarily or automatically by operation of law. Automatic termination occurs when certain legal or factual circumstances render the continuation of agency impossible or unlawful. Unlike voluntary termination, which occurs by mutual agreement or revocation, automatic termination happens by default, without either party needing to act. One of the most common automatic terminations arises upon the death or incapacity of either the client or the broker. In real estate law, agency is based on personal trust and representation. If the client passes away, the broker no longer has authority to act on their behalf. Similarly, if a broker loses their license, becomes incapacitated, or dies, the agency relationship with all clients under that broker automatically ends. This principle stems from the common law doctrine of agency and is reinforced through the fiduciary nature of the relationship. In Arizona, when a designated broker dies, all licensees under that broker must immediately cease license activities until they are reassigned to another employing broker, as required under ARS Section 32-2127B. For example, consider a situation where a buyer's broker is hospitalized and declared legally incapacitated. The buyer cannot continue working under that agency agreement because the broker can no longer legally represent them. The buyer may immediately hire a new broker to continue the transaction. Similarly, if a seller passes away during a listing period, the listing agreement terminates automatically. However, if the property is part of an estate, the personal representative of the estate may choose to enter into a new listing agreement with the broker to continue marketing the property. Another event that automatically terminates agency is the fulfillment of the purpose of the agreement. Once the property has been sold, the lease executed, or the transaction otherwise completed, the agency relationship concludes. Although fiduciary duties, such as confidentiality and proper accounting, persist beyond the transaction, the active authority to negotiate or act on the client's behalf ends immediately upon closing. Agency also terminates automatically by destruction or condemnation of the property. When the subject matter of an agency no longer exists, the basis for representation disappears as well. For instance, if a house burns down before closing, the listing agreement terminates automatically. The broker cannot continue to market a property that no longer exists. This same rule applies if the government exercises its power of eminent domain and condemns the property. A change in law can also automatically terminate agency. If a new statute or court ruling makes the transaction illegal or prohibits the broker's actions, the agency ends immediately. For example, if zoning changes prohibit a proposed commercial use for which a broker was hired to secure a lease, the broker's authority to act is nullified. Similarly, if the state suspends or revokes the broker's license under ARS Section 322153, the agency relationship with clients automatically ends. A more subtle example involves bankruptcy. If either party in an agency relationship is declared bankrupt, the agency may terminate automatically depending on the circumstances. For instance, if a seller files for bankruptcy, control of their assets transfers to the bankruptcy trustee, who then decides whether to continue or cancel any agency agreements. The agent's authority ends unless the trustee specifically reauthorizes it. While automatic termination ends the licensee's active representation, the fiduciary duty of confidentiality survives beyond termination. Under R 4-28-1101E, a licensee must not disclose confidential information gained during the agency relationship unless required by law. For example, even after a listing ends, the agent cannot reveal the seller's bottom line price, motivation for selling, or private financial information. This continuing duty protects clients long after agency authority has ended. Case law reinforces these principles. In Lombardo v. Albu, 1996, the Arizona Court of Appeals reaffirmed that fiduciary duties end when the agency relationship terminates, except for confidentiality and accounting. The court noted that once the purpose of the agency is fulfilled or the principal dies, the agent's authority ceases immediately. However, if the agent continues to act without authority after termination, any resulting transaction is void, and the agent may face disciplinary action under ARS Section 32-2153, A3 for unlicensed or unauthorized conduct. For example, imagine a scenario in which a listing agreement expired last week, but the broker continues to advertise the property. Even if the seller later decides to renew the listing, the broker's actions during the expired period could violate advertising and agency rules. The ADRE has disciplined agents in such cases for misleading the public by appearing to act under expired authority. Understanding automatic termination also protects brokers from potential liability. If an agent continues to act after termination, they may be personally liable for damages or misrepresentation. Likewise, clients who fail to notify their brokers of events that automatically terminate agency, such as death or bankruptcy, may create confusion that could delay closing or lead to disputes review. Summary agency relationships automatically terminate upon death or incapacity of the broker or client, destruction or condemnation of the property, fulfillment of purpose, expiration of agreement, change in law, or loss of license. Although active authority ends, fiduciary duties such as confidentiality and accounting survive. Acting beyond the termination of agency may result in legal or disciplinary consequences under ARS Section 32-2153A3. Cases like Lombardo versus Albu affirm that agency authority ceases by operation of law when its foundation is lost. Discussion. Why does the death or incapacity of a broker automatically terminate an agency relationship? Answer. Because agency is based on personal representation, and the broker's authority cannot survive once they are legally unable to act. What happens to confidentiality after agency termination? Answer. The duty of confidentiality continues even after the agency ends, as required under R4-28-1101E. Why can a broker not continue advertising a property after a listing expires? Answer. Because continuing to advertise would mislead the public into believing the broker still has authority, violating ARS Section 32-2153, A3, and ADRE advertising rules. Closing remarks. Automatic termination of agency is a fundamental safeguard that ensures the real estate process remains lawful, ethical, and clearly defined. It prevents unauthorized actions and reinforces the boundaries of a licensee's authority. While agency ends when the purpose is fulfilled or circumstances change, professionalism does not. The enduring duties of honesty, confidentiality, and accountability continue long after the transaction has closed. Recognizing when agency terminates and acting accordingly is one of the hallmarks of an ethical and competent Arizona real estate professional.